Welcome back, everyone. We're continuing our educational series, really digging into the MPEP one piece at a time.
Doing that deep dive. And before we get going, a big thank you to Mike Shepard, our creative director, for putting this whole series together.
Absolutely. Essential stuff.
So today, we're tackling, well, it sounds bureaucratic, but it's utterly vital. MPEP Chapter 300. It's all about ownership and assignment.
Right. Who owns the patent? And maybe more importantly, how does the USPTO know who owns it? How's it tracked?
Exactly. It's about the nuts and bolts, the formal procedures, how these rights, which are personal property under 35 U.S.C. 261, get transferred, and how that transfer gets recognized officially.
It sounds like paperwork, but it really dictates who can actually do things with the patent.
It really does. But first, you know the drill. We have that necessary disclaimer for the series.
Understood. Okay, here it is. Disclaimer. This summary of the MTEP was generated using AI tools, including ChatGPT and NotebookLM, and may contain errors or omissions. It is provided for general educational and informational purposes only and is not legal advice or a substitute for formal instruction. For authoritative guidance, consult the official MPEP, a qualified instructor, or a registered patent practitioner.
Okay, formalities done.
Right. So let's dive in. Chapter 300. Patents as property. We know it needs a written assignment, but let's talk about when things get complicated, like joint ownership. What are the real risks there?
Oh, this is where it gets really interesting and potentially quite risky if you haven't planned ahead. Under 35 U.S.C. 262, the default rule is, well, each joint owner can independently make, use, or sell the invention.
Independently, meaning without asking the other owner.
Precisely, without their consent.
Hold on. So say I invent something brilliant with a partner, we get a patent. If we don't have a separate contract, my partner could just license it to some huge company without even telling me.
That's exactly right. And here's the real kicker, as they say. Your partner generally has no legal duty, no statutory duty, to share any of the money they make from that license with you.
Wow.
None. None by default. They can exploit the patent entirely on their own, potentially draining its value for exclusive deals later, and you wouldn't see a dime unless you had a prior agreement spelling out profit sharing or requiring joint consent.
Okay. That single rule makes understanding Chapter 300 incredibly important for anyone collaborating on inventions. That's a huge takeaway right there.
It absolutely is.
So, all right, let's say the rights have been assigned, maybe fully to a company or maybe partially. The new owner wants to, I don't know, pay a maintenance fee or respond to an office action. They can't just waltz in, can they? There's this gatekeeper step.
That's a good way to put it. Yeah, the gatekeepers. Before any assignee can take official action on a patent file, they have to prove their ownership. They need to satisfy the director, following the rules in 37 CFR 3.73.
And proof means more than just saying, I own this now, right? What kind of documentation does the USPTO actually need?
Right. It's two key things generally. First, a statement signed identifying who the assignee is. Second, and this is crucial, documentary evidence of the ownership transfer. Usually that's a copy of the actual assignment agreement showing that chain of title.
Okay.
But here's the procedural twist for patent matters. The submission also has to confirm that this evidence, this assignment document, either was recorded previously or is being submitted for recordation right now concurrently.
So you have to link the internal action on the patent file with the public recordation process. Why is that mandatory?
It's really about transparency and, well, preventing potential issues. The USPTO wants the public record to reflect who has the authority to act. You can't just sort of privately assert ownership to manage the patent file without also making that ownership claim public through the recording system. It keeps things aligned.
Okay, that makes sense. Prevents confusion down the line. And what if the ownership is split? Say two companies each own 50%. How do they act together?
Good question. The USPTO needs to know they're dealing with the entire ownership interest. So each partial owner has to submit their own statement detailing their share, or if maybe the shares aren't explicitly defined like that, they need to jointly affirm that, yes, together they represent the full 100% right, title, and interest.
Got it. Ensures no one with a stake is left out when actions are taken.
Exactly. It protects the integrity of the process.
This leads us perfectly into Section 2, which I think has one of the most important concepts in this whole chapter for people to really understand. It's the difference between recording an assignment and that assignment actually being legally valid.
Yes. This is the aha moment, like you said. It clarifies what the USPTO does and maybe more importantly what it doesn't do. Remember, there are two main reasons to make an assignment of record. One is just for public notice in the big assignment database, and the other is to file it in a specific application file so the assignee can take action.
Okay, two purposes. But the key insight, the really critical point, is that recordation itself is just a ministerial act. The USPTO isn't actually verifying the contract, are they?
That's absolutely correct. Think of the USPTO recordation system like a giant public filing cabinet. They take your document, they put a timestamp on it, they list it so the public can see it exists. But, and this is the big stale, but they explicitly do not investigate or rule on whether the assignment contract itself is legally sound, whether it was properly signed, whether it actually transfers ownership effectively under contract law.
So they don't check if the person signing even had the authority to sign for the company.
Nope, that's outside their scope for recordation. Case law like Realvert v. Lee really emphasized this. The USPTO's role here is procedural. It's administrative, not judicial. They provide the notice that a transfer is claimed, but they don't validate the transfer itself.
Okay, so this has huge implications. If I'm a company looking to buy a patent, and I just check the USPTO assignment records, I could be looking at a recorded assignment that looks official, but is actually legally worthless, maybe due to fraud or some internal mistake.
Precisely. That's the risk. You
Yeah.
could have an assignment recorded that, say, wasn't signed correctly according to state law, or maybe it refers to the wrong patent, or was signed by someone who didn't actually have corporate authority. It's recorded, so it gives public notice of the claim, but the underlying legal transfer might be completely invalid.
Wow. So the burden of due diligence, checking the actual legal validity of the assignment, that falls entirely on the parties involved in the transaction, like the buyer or licensee. The USPTO record is just step one, the notice step.
Exactly. The ministerial act nature of recordation puts the onus squarely on you to verify the substance.
That's a crucial point. And while we're talking transfers, Chapter 300 also makes a distinction between a full assignment and a license, right?
Yes, that's another fundamental distinction. An assignment transfers the actual ownership, the title. A license, on the other hand, is more like granting permission. It conveys certain rights, maybe to use the invention only in a specific territory, or only for a certain type of product, but the original owner keeps the title.
So like giving a company the right to make and sell my patented widget just in California, that's a license. But selling the entire patent, lock, stock, and barrel, to another company worldwide, that's an assignment.
Perfect example. Exactly right.
Now, given that recordation is so important for that public notice function, what happens if there's a mistake, like
Oh.
a simple typo in the serial number or the company name on the assignment document after it's already been recorded? How do you fix that?
Yeah, errors happen. If the mistake is in the actual legal document that was recorded, the best way, the cleanest way, is usually for the parties who made the original document, typically the assigner, to create and record a new corrected assignment or an instrument fixing the error.
Okay, a corrective document. But what if that's not possible? Maybe the original company doesn't exist anymore.
Right, that can happen. In those situations, the assignee, the current owner, can submit an affidavit, basically a sworn statement that identifies the error clearly and requests that the USPTO records be corrected. There's precedent for this, like in the ABACAB case mentioned in the MPPP, which allows for fixing these kinds of chain of title glitches administratively, assuming the underlying transfer was actually intended and valid otherwise.
Good to know there's a mechanism for that. Okay, let's shift gears a bit to Section 3, the real procedural nitty-gritty, how you actually file things, especially electronically. It all seems to hinge on this thing called the S signature.
Ah, yes, the S signature. It sounds minor, but it's a classic example of a strict technical rule that's absolutely essential for the USPTO's electronic filing systems, like the Electronic Patent Assignment System, or EPAS.
And the requirements are really specific, aren't they?
Very specific. The signature itself has to be just letters, numbers, or basic punctuation like commas, periods, apostrophes, hyphens, nothing else.
And the key visual part is the slashes.
Yeah, exactly. The whole signature string must be enclosed between single forward slashes. So like Jane Q. Public or Dr. John Smith 123. The reason for this rigidity is that it allows the USPTO's systems to automatically parse and verify the signature field reliably. Any deviation, like using fancy fonts or extra symbols, could cause the system to reject the submission.
So follow the format exactly, or risk delays. And if you're a registered patent attorney or agent signing,
There's an extra step. You have to include your registration number. It can be part of the name string within the slashes or placed right next to it. This directly links the electronic submission to someone authorized to practice before the USPTO. It's another layer of authentication.
makes sense. Accountability. Now, thinking about transfers again, Let's say a startup assigned its key patent application to a bigger company that just acquired them. Does that assignment automatically cancel the power of attorney given to the startup's original law firm?
That's a really practical question, and the answer is strategically, no. The assignment itself doesn't automatically revoke the existing power of attorney, and that rule, 37 CFR 1.36, is actually designed to prevent disruption.
Ah, so the application doesn't just grind to a halt while the new owner finds new lawyers.
Exactly. It ensures continuity. However, the assignment does make the new company the official applicant. And as the applicant, the new owner now has the full authority to revoke that old power of attorney and appoint their own counsel whenever they choose.
So it provides a smooth transition, but ultimately gives control to the new owner. Seems like a sensible balance.
It generally works well.
Okay, finally, we should briefly touch on how the America Invents Act, the AIA, affected some of these procedures, specifically around patent issuance when there's an assignee.
Right. The AIA implemented some major changes, and the key date everyone remembers is September 16th, 2012. MPA Prio 8 points out that the procedures for actually issuing a patent in the assignee's name can differ depending on whether the application was filed before or after that date.
And what was the main practical difference, say, for something like a reissue application?
Well, before the AIA, the inventor was generally the primary applicant, the one who had to sign the oath or declaration. There were some exceptions, like MP 1400 mentions for pre-AIA reissues, if the assignee owned the entire interest and the reissue wasn't broadening the claims, then the assignee could file it.
Okay, a limited exception.
Right. The AIA really simplified things by generally allowing the assignee to be the applicant right from the start in most situations. It just reflects the modern reality better, where companies, not just individual inventors, are often driving the patenting process.
So bringing it all together for Chapter 300. The big picture seems to be that patent ownership is treated like other property, but managing it within the USPTO system demands really strict adherence to procedures. Transparency, formal steps like S-signatures, accurate recording. It's all about clearly defining who has the rights.
It is. It's a lot of procedural heavy lifting, you could say, but it's necessary to maintain legal clarity in the system. And understanding these rules, especially that critical difference between just recording an assignment for notice versus its actual legal validity, is absolutely fundamental if you're working in this space.
Which leads us perfectly to our final thought for you, the listener, to chew on. If, as we've discussed, the USPTO's act of recording an assignment is purely ministerial, they don't actually validate the underlying legal transfer, how does that reality change the game for due diligence? When you're looking to license or buy a patent, potentially worth millions, what does that public notice function really tell you, and what else do you absolutely need to investigate beyond the USPTO's public records to truly protect your investment?
Yeah, it's a great question. That seemingly small procedural detail ministerial act has massive real-world consequences for how much homework you need to do.
Definitely something to think about. Thank you for joining us for this deep dive into MPEP Chapter 300. We'll catch you on the next one.